good enough.
Alfred Naro.
Thank you. I rise to take a call on the Legal Assistant Amendment Bill, especially in regards to its title and clauses. Mr Chair, I actually do agree with the Honourable Leanne Dalziel, hearing those real cases of real people in real places and the impact that it has. And I think that's important because when we're doing this, we take those into consideration with the regulatory impact statement. The comments by the member Chris Farfoy talking about the word sustainability, the intent, if the member actually would read the bill, actually talks about the importance that the legal assistance be affordable into the future and available to those who need it most. I think that's really is our concern. When we look at the ongoing growing costs that there are, we know that, for instance, it was petitioned by the Honourable Member Leanne Dalziel and also to our previous Member of Parliament, Charles Chauvel, who actually asked that the Minister consider pausing the actual bill at the legal assistance bill so that we could take into account the review that was being taken place by the Ministry of Justice in regards to the Family Court review. And it's acknowledged that that time was taken, the Family Court review was then conducted, completed, and then therefore the Legal Assistant Amendment Bill was taken in consideration with that. So it's important to actually be able to see, the fact is that when we talk about electorate, our communities that we're talking about, and so we...
A point of order, Tim McIntyre.
But ever since he spoke, he started speaking, the level of interjection, particularly from Mr Cunliffe, has been unreasonable.
I'm the judge of that. Alfred Naro.
Thank you, Mr Chair. So, Mr Chair, it very much is the concern of the committee, of the Justice Electoral Select Committee, when we heard the submissions, to ensure that legal aid was available, but most importantly, not only just for the now, but into the future as well. Sustainability was absolutely important to us. We realised that the importance that, at the moment, that the budget for 2011 included $103.5 million in the short-term funding, while longer-term sustainability issues were addressed through both this bill, the wider review of the Family Court, which would include $138 million over 4 years. Mr Chair, we know that adjusting the eligibility for legal aid was important, and it does make it sustainable in this. So tightening the merits test for family cases by no longer needing to take into account the interests of other vulnerable parties. Adjusting the special circumstances consideration in the means test for family and civil cases so that it focuses on expensive cases. Mr Chair, we know, and I know Mr Farfoy knows, in his community and even the fraternity, the legal fraternity talks about in the electorate of Mana, the number of cases in which a number of our people who needed legal aid, who should have access to legal aid, this bill will not remove it from them. In fact, if anything, it will make it easier and more accessible. And if he reads the details, he will see this. He will see this. Well, it's important, Mr Speaker, that...
A point of order. I believe under the standing orders governing misrepresentation, the minister has, the member has misrepresented the government's position. This bill tightens the provisions of legal aid.
Sit down. Look, that's not a point of order. These are debating points. Alfred Naro.
Thank you, Mr Chair, for your wise counsel. So, Mr Chair, we know that adjusting eligibility for legal aid is important, removing the requirement to index means thresholds to movements in the Consumer Price Index, simplifying the administration of funding of legal aid for offenders for parole board appearances so that all such cases are classified as criminal legal aid. This bill increases payments by legally aided people, Mr Chair. This encourages people to actually take consideration of whether they need legal aid or not, and to think about whether they wish to proceed with litigation, and provides incentives for repayment of legal aid. Mr Chair, we believe that the changes that have been made to this amendment, in consideration of the wider context of the Family Court review with the Family Court Proceedings Bill, actually not only is sustainable for the future, but also does make legal aid accessible to our communities of need and to our vulnerable communities. Mr Chair, I commend this clause.
Members, the question is that Clause 1 stand part. Those of that opinion will say aye. To the contrary, no. The ayes have it. There's a party vote's been called for. Ask the clerk for the party vote.
New Zealand National.
59 votes in favour.
New Zealand Labour.
33 votes opposed.
Green Party.
14 opposed.
New Zealand First.
7 votes opposed.
Māori Party.
2 votes opposed.
Mana.
1 vote opposed.
Act New Zealand.
1 vote in favour.
Honourable Peter Dunn.
1 in favour.
Brendan Horan.
1 vote opposed.
Members, the ayes are 61, the noes are 58. Clause 1 will stand part. The question now is that Clause 2 stand part. Those of that opinion will say aye. To the contrary, no. The ayes have it. Is it? Party votes called for. Ask the clerk for a party vote.
New Zealand National.
59 votes in favour.
New Zealand Labour.
33 votes opposed.
Green Party.
14 opposed.
New Zealand First.
7 votes opposed.
Māori Party.
2 votes opposed.
Mana.
1 vote opposed.
Act New Zealand.
1 in favour.
Honourable Peter Dunn.
1 in favour.
Brendan Horan.
1 opposed.
Members, the ayes are 61, the noes are 58. Clause 2 will stand part.
Mr Chair.
The Honourable Amy Adams.
Mr Chair, I move supplementary order paper number 251, dividing the bill.
The question is that the motion be agreed to. Those of that opinion will say aye. To the contrary, no. The ayes have it. I will report this bill with amendment and so divided presently. Members, we now come to the State Sector and Public Finance Reform Bill. The question is that Part 1 stand part. This is debate on clauses 3 to 57C and Schedule 1. The Honourable David